Facts: Attorney Noel V. Antari, Jr., Attorney Ernesto A. Tabujara III, Attorney Israel P. Calderon, Attorney Morgan Rosales Nicanor and Attorney Joseph Marian Pena Navarrete, posted the following conversation. SP Leon Yatna, Attorney Noel V. Antari, Jr. just prosecuted and helped convict a member of the LGBTA community for large-scale estafa. The new convict then began cussing at me, accusing me of being a bigot. A first for me. Smile emoji. The judge, who is somewhat effeminate, comes to my defense and warns the felon to behave. All in a day's work. Smile emoji, smile emoji, smile emoji. Ernesto Tabujara III. Sino Young Bakla na Judge SA Tagwig SA MTC SA First Floor. Naka eyeliner and eye shadow pag nag he hearing. Omtore pa. SP Leon Yatna. Napromote na yon, boss Tiki. RTC Judge na kaya yon. Smile emoji, smile emoji, smile emoji. Ernesto Tabujara III. The joke among lawyers is that SA Tagwig SA Second Floor Puro May Sira SA Yulo MGA Judge, SA Baba Bakla at MGA Corrupt. SP Leon Yatna. No comment, boss Tiki. May MGA Keso pa AKO dun e. Smile emoji, smile emoji, smile emoji. Dendan Calderon, Attorney Israel P. Calderon. Baka type ka. SP Leon Yatna. Bad ka, Professor Smile emoji. Dendan Calderon. SP Leon Yatna Malay Mo Nikita Enya Intelligence Mo given na good looks and na convict Mo pa esya. Tapo siempre di ka mapipasakame Enya kaya ayon imbirna ay charat haha. SP Leon Yatna. Ang bad Mo sakin, Professor Smile emoji. Morgan Nicanor. SP Leon Yatna oo tama. Feel ko type ka bossing. He. SP Leon Yatna. Ay anak in garapan. Dalawang profs na smile emoji, smile emoji, smile emoji. Ernesto Tabujara III. Dapat kinurat mo. Charat. Joseph Marian Navarrete. Morgan Nicanor natitandan ko yung kliyente mo dinala SA Ombudsman. SP Leon Yatna. Kwento ka naman, Prosec Joseph Smile emoji. Joseph Marian Navarrete. Pinyatawag lang AKO ing Professor Morgan Nicanor MGA panahon na yan. Tapos bit naya kliyente naya. Ang natatandan ko lang is malagkit tinjin kay Papa, este Professor Morgan. SP Leon Yatna. Matikas kasi SI Professor Morgan habulin. Smile emoji.
Through his compliance, Attorney Antari, Jr. expressed his deep remorse and profound shame over the incident and extends his sincerest apologies for whatever anxiety and alarm that his posts might have caused. He further asserts that he could barely remember the posts and was only reminded of them when he saw screenshots that had begun circulating. He could no longer recover the posts through his social media account, and he can only rely on the unauthenticated screenshots and the forwarded copy of this court's resolution. He had not yet been served a copy thereof. What makes the incident more perplexing is that his social media profile is locked and its contents cannot be accessed by outsiders. He has always been discreet and private in his personal dealings. He has no excuse about the incident and is mortified of how the breach occurred. He had no intention of disrespecting any magistrate or undermining the judiciary. His posts did not single out or disparage anyone. His use of the phrase member of the LGBT community was merely descriptive, not disparaging nor disrespectful. The word effeminate was not used to describe a particular magistrate, but merely to describe a non-antagonistic and non-threatening demeanor. He never dreams of discriminating against or disparaging any member of the lesbian, gay, bisexual, transsexual, queer or questioning, intersex, asexual, and more LGBTQIA+ community. He even tried to politely put an end to the conversation by saying, bad ka. Attorney Nicanor, Attorney Navarrete, Attorney Tabujara III, also explained that they never intended to malign, degrade, or debase any member of the judiciary or the LGBTQIA+ community. By resolution dated June 21, 2022, the court referred the matter to the Office of the Bar Confidant for investigation, report, and recommendation. Issues. 1. Can the erring lawyers invoke their right to privacy as a shield against administrative liability, if any? 2. What are the respective violations, if any, of the Code of Professional Responsibility committed by Addis, Antayi, Jr., Tabajara III, Calderon, Nicanor, and Navarrete? 1. Can the erring lawyers invoke their right to privacy as a shield against administrative liability, if any? No. The lawyer's right to privacy, especially when it comes to their social media account, is limited. They cannot use this right as a shield against any liability. At best, the right to privacy has limited application to online activities of lawyers. On this score, Belo Henares v. Attorney Guevara, Belo Henares, comprehensively explains. Consequently, before one can have an expectation of privacy in his or her online social networking activity, in this case, Facebook, it is first necessary that said user manifest the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. This intention can materialize in cyberspace through the utilization of Facebook's privacy tools. In other words, utilization of these privacy tools is the manifestation, in the cyber world, of the user's invocation of his or her right to informational privacy. Moreover, even if the court were to accept respondent's allegation that his posts were limited to or viewable by his friends only, there is no assurance that the same or other digital content that he uploads or publishes on his Facebook profile will be safeguarded as within the confines of privacy in light of the following. 1. Facebook allows the world to be more open and connected by giving its users the tools to interact and share in any conceivable way. 2. A good number of Facebook users befriend other users who are total strangers. 3. The sheer number of friends one user has, usually by the hundreds, and 4. A user's Facebook friend can share the former's post or tag others who are not Facebook friends with the former, despite its being visible only to his or her own Facebook friends. Thus, restricting the privacy of one's Facebook posts to friends does not guarantee absolute protection from the prying eyes of another user who does not belong to one circle of friends. The user's own Facebook friend can share said content or tag his or her own Facebook friend thereto, regardless of whether the user tagged by the latter is Facebook friends or not with the former. Also, when the post is shared or when a person is tagged, the respective Facebook friends of the person who shared the post or who was tagged can view the post, the privacy setting of which was set at friends. Under the circumstances, therefore, respondents' claim of violation of right to privacy is negated. At any rate, even granting veracity to Attorney Antayi, Jr.'s allegations, no reasonable expectation of privacy arises in this case. It is settled that in ascertaining whether there is a violation of the right to privacy, the test is whether a person has a reasonable expectation of privacy and whether the expectation has been violated. This, in turn, entails a two-part test. 1. Whether, by a person's conduct, such individual has exhibited an expectation of privacy. And 2. This expectation is one that society recognizes as reasonable. On this score, Belo Henares is clear. There can be no reasonable expectation of privacy as regards social media postings, regardless if the same are locked, precisely because the access restriction settings in social media platforms do not absolutely bar other users from obtaining access to the same. 2. What are the respective violations, if any, of the Code of Professional Responsibility committed by Addis, Antayi, Jr., Tabajara III, Calderon, Nicanor, and Navarrete? The applicable provision of the CPR is Rule 7.03, viz. Rule 7.03, a lawyer shall not engage in conduct that adversely reflects on his fitness to practice law, nor shall he, whether in public or private life, behave in a scandalous manner to the discredit of the legal profession. Indeed, lawyers, as keepers of public faith, are burdened with a high degree of social responsibility and, hence, must handle their personal affairs with great caution. Citing a new Belo Henares v. Attorney Guevara, the court suspended attorney Roberto C. Guevara for 1 year from the practice of law for his defamatory posts on Facebook. The court noted his breach of Rule 7.03 in this wise. Lawyers may be disciplined even for any conduct committed in their private capacity, as long as their misconduct reflects their want of probity or good demeanor, a good character being an essential qualification for the admission to the practice of law and for continuance of such privilege. When the Code of Professional Responsibility or the Rules of Court speaks of conduct or misconduct, the reference is not confined to one's behavior exhibited in connection with the performance of lawyers' professional duties, but also covers any misconduct, which, albeit unrelated to the actual practice of their profession, would show them to be unfit for the office and unworthy of the privileges which their license and the law invest in them. Accordingly, the court finds that respondent should be suspended from the practice of law for a period of 1 year, as originally recommended by the IBPCBD, with a stem warning that a repetition of the same or similar act shall be dealt with more severely. 2. Section 2 of Republic Act No. 1131335, also known as the Safe Spaces Act, explicitly states that it is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. It is likewise the policy of the state to recognize the role of women in nation building and ensure the fundamental equality before the law of women and men. The state also recognizes that both men and women must have equality, security, and safety not only in private, but also on the streets, public spaces, online, workplaces, and educational and training institutions. Verily, members of the legal profession may simultaneously incur administrative, civil, and criminal liability on the basis of their language alone. It goes without saying that lawyers are held to a higher standard, as they all took the lawyer's oath, by which they all committed to support the Constitution and obey the laws as well as the legal orders of the duly constituted authorities therein. Here, the court is disturbed by the unapologizing stance of Attorney Tubajara III and his seeming disregard of his position as molder of minds of soon-to-be lawyers, who was tasked with guiding his students to behave and act in a manner consistent with the lofty standards of the legal profession. Nor can his claims of being an ally and supporter of the LGBTQIA+ community absolve him of any liability. In fact, it smacks of hypocrisy, for if he was truly unbiased, he would have refrained from engaging in a homophobic and disrespectful conversation. No one consciously and intentionally disrespect or humiliate those they hold with esteem and affection. And if hurt was unintentionally inflicted, a sincere apology can lessen the sting. Consequently, like in Tianco, Attorney Tabajara III must be sanctioned. We, however, cannot follow the penalty imposed in Tianco. For one, Tianco is dated. For another, the power of social media has multiplied the adverse impact of the statements of Attorney Tabajara III countless times. Hence, he is fined 25,000 pesos with stern warning that a repetition of the same or similar offense will be dealt with more severely. Accordingly, the court resolves to 1. Reprimand Attorney Morgan Rosales Nicaner, Attorney Joseph Marion Pena Navarrete, Attorney Noel V. Antai, Jr., and Attorney Israel P. Calderon for violation of Rule 7.03 of the Code of Professional Responsibility, with stern warning that a repetition of the same or similar offense will be dealt with more severely, and 2. Impose a fine in the amount of 25,000 pesos on Attorney Ernesto A. Tabajara III for violation of Rule 7.03 of the Code of Professional Responsibility, with stern warning that a repetition of the same or similar offense will be dealt with more severely.